Welcome to the Financial Beast Podcast. I'm your BFFF, best financial friend forever, Eric Miller. Now, look, I'm talking about being a financial beast. We're talking about being on the attack, but there are some times where we have to step back and we have to protect what we've earned. And I just had a great conversation with an employment attorney. Her name is Devora Lindeman. She works with a company called Greenwald Doherty. And I know what you're thinking right now. Oh my gosh, this is an attorney. It's going to be boring. It's going to be mundane. No. We talked about the things that you need to know as a business owner, as a practice owner, when it comes to dealing with your employees. Nobody likes to fire people. Nobody wants to let people go. But these are things that we have to do. And you got to make sure that you're doing it in the right way so that it doesn't snap back on you and you get sued or you open yourself up to a lawsuit and the time and attention and money that includes. So I think you're going to really enjoy this conversation. We talk about that and a whole lot more when it comes to hiring and firing practices. So enjoy the podcast. Make sure that you like, subscribe, and share this podcast. And look, if you are in a position where you need financial help, I want to make sure you go to wealthforpracticeowners.com, wealthforpracticeowners.com. And we have plenty of information, downloads, assessment. Most importantly, you can connect with us. You can talk to a specialist and we can get you on the fast track to improving your financial condition. Enjoy the podcast. I'll see you on the next one. Well, hello, Devora. Thank you for being here.
Oh, you're welcome, Eric. Thank you for inviting me.
We're going to talk about like the favorite subject of every business owner, right? Which has to do with protecting their business and how to deal with tough situations. We're going to cover a lot of things today, so I think we'll get into it. But as a precursor, in dealing with practice owners and business owners for the last 15 years, I tend to find the area that they do not like to really either confront or, just someone else can look at that is what we call the protection area. Now, when I say the protection area, it's like, protecting myself from lawsuits, protecting myself from, having insurances to protect myself. But, your specialty is more on the business side and I guess you could say HR side. Would that be a safe assessment to say?
Exactly. It's employment law. So anything that deals with having employees, I'm the type of lawyer that when an HR person doesn't want to get the company sued, they call me.
Excellent. So we're definitely in the right place and we're at the right time right now because there's a number of things that as people are, most of the people that we deal with have multiple employees, but they just lack a lot of the basic things that I think a lot of businesses need to protect themselves, from employees or having to let people go and all of these things. And I guess, I just want to ask you, like, why is it, because I'm sure you see a lot of businesses, they come to you, what is it? Why is this an area that's so neglected, do you think?
It seems to be, to me, an area that business owners can't confront. And I think one of the reasons for that is they lack information about what to do and what it is they're supposed to do under the law. When you know what it is that you need to be doing, then you can just go ahead and do it. But the employment law, HR, dealing with employees, being afraid that employees are going to sue you, it becomes a whole area that business owners have a lot of back off. So one of the things that we do in our practice is we do a lot of training for managers, for executive, for HR people, so that they know what it is that they're supposed to be doing.
How did you get into this area? Like, what was the moment that you're like, okay, this is an area that I'm good at. I know this, and a lot of people need help.
That's kind of interesting. This is the only area of law that I've ever practiced is employment law, but law isn't my first career. actually graduated law school when I was 39. So I had a lot of business background before I even went to law school. So I really knew the world of work. I worked in nonprofit sector. I worked in the for-profit sector. I even worked in some blue-collar jobs, white-collar jobs, all kinds of things. But when I was in law school and right after, when I was trying to figure out what it is I wanted to do, I had a whole list of things I didn't want to do. Didn't want to do criminal law. I didn't want to do family law. I couldn't deal with those emotions. I didn't want to do plain business law because I really didn't care to litigate why the widgets didn't arrive on Tuesday. I was not really good at either science or math. So no tax law, no securities law, nothing to do with environmental protection.
You just X'd everything out until you got to the bottom of the page, didn't you?
To some degree, but I was clerking for a judge after law school in the District of New Jersey Federal Court. And he suggested employment law. He knew my background. He knew what I was capable of. And the world of work made sense to me. It has a little bit of human emotion involved, but not the same type of things as family law. And it, again, made sense to me. So that's how I wound up in employment law for businesses. I've only done the business side. And all the years I've been practicing around 27, something like that.
Yeah. So confronting this area is a big mistake. I think a lot of people definitely don't do. And then I'm assuming a lot of them just, do they know where to go to get advice on this? Where do they usually go to find out about these kinds of things?
Google.
Yeah. Okay.
They try to get a Google law degree. I very often have potential clients calling me because I said, well, I tried to Google this and it didn't make any sense to me. So I figured I should call a lawyer. Or they go to their lawyer, but their lawyer is a real estate lawyer or a business lawyer or an intellectual property lawyer or something else related to their business. They're not an employment lawyer. And this is a very specific niche of what we do to help our business clients comply with all these crazy employment laws that apply when you have employees. And we also try to help them achieve their business goals at the same time.
Yes. So I want to try to start at the beginning here. I'm just going to take, because we deal with a lot of practice owners, and most of our clientele, people that are listening to this, are like veterinarians and dentists and physical therapists and such. And okay, so I have maybe 10 to 15 employees, right? What do I have to worry about with this? I mean, that's a pretty broad question right there, but like, where do I start with your area of expertise to help protect myself with having this many employees?
I'm pausing because I'm trying to figure out where to start, because you're right, there are a lot of things. So there's one thing I'm going to mention, but I'm going to put on the side, which is depending on the state where the practice is located, there could be some specific things that need to be done. I'm not going to talk about any state-specific things. That's why I'm sort of putting that on the side.
That makes sense.
The next thing is that the practice owner needs to make sure that the expectations are communicated to the employees. And there's going to be two sets of expectations. There's going to be expectations generally of employees that work for that practice. Things like, how do we generally treat our patients? What do we do if we're going to be absent? What kind of environment are we trying to create here? More general requirements. And then there's also going to be requirements that are specific to a job. For example, in a dental practice, your dental hygienist or dental assistants are going to have certain specific expectations where the front desk receptionist or the treatment coordinator or the scheduler are going to have other things that are specific to their jobs. So for each employee, it's very important to have, for example, a job description that outlines what each employee is supposed to do. Because one of the key things that business owners need to do, or they need to delegate, so someone does it, is performance managing those employees to make sure they're doing what the practice expects. And this really is simply, here's a list of what you need to do. When they don't, you tell them, hey, you're not doing it. Look back at this list. You're supposed to do X, Y, Z, and give them an opportunity to try again. And if eventually they don't do it, you're down the road to letting them go. But you've told them what they needed to do. You've given them some chances to improve. And when you get to the point that you're letting them go, they shouldn't be surprised by that termination conversation.
That's excellent. So there's really two tiers. It sounds like there's something that you said, you have something in writing that of the expectations of the kind of employee that we expect you to be just in general. And then there's also the expectations for your particular job. And that's something that needs to be written up, obviously by the owner, as part of their policy and procedure handbook, or is that a separate conversation?
That's two different things. Policy and procedures, or the employee handbook, would outline all the policies and expectations that apply to everybody, everybody working in the practice. A job description, or perhaps process and procedure memos that prior occupants of that job may have written up and said, hey, I find it easy to do this. Or let's say somebody is getting supplies for the practice and they say, here, use this vendor, and here's who you talk to, and here's how you get discounts. And they, write up a more specific procedure memo than you would put in a job description. The job description and that procedure memo are specific for a job.
Yes. Why is this so hard to do? Is it just?
It's a really good question, but let's take your client base. If you're looking at dentists or veterinarians or other types of doctors or medical practitioners, those people are the people that are doing the service delivery for their business. They're most often not the ones actually running the business. And for that reason, I generally recommend that they need somebody, whether it's a general manager, an office manager. Sometimes I have a front desk, or front of the practice manager, and then a back of the house manager, that do more of the actual managing of the behind the scenes, rather than, like I say, because I have a lot of dentist clients as well and doctor clients. I want my dentist clients to have their hands in somebody's mouth. That's what they should be doing. They should be delivering.
That's how they make their money.
Exactly. They don't really have time to do all these administrative tasks that businesses actually need to do in order to make sure that their business flourishes and prospers, which mean those business owners either have to do it themselves, figure out a way to carve out some time, or they have to delegate it to somebody.
Yes. And either way, it's seemingly going to take away from their production. But it's, I look at this too, especially when a lot of these dentists or whoever it is are going to sell their practice and they don't have these things in place. I think it makes it less valuable as an overall, the practice value when you don't have the compliance on these businesses. It's a big red flag, I know, for a lot of buyers. Because if I'm walking into a business and there's no policy and procedure, there's no handbook, there's no job descriptions, there's no anything, I'm like, oh my God. I'm surprised you're still functioning at this point in time.
That's a really good point, because very often what either the buyer or seller is looking at is their patient list. How many patients, how much money did they make? But without those policies and procedures in place so that the staff knows what to do, then that's probably not sustainable going forward.
No, I would definitely say it's not. Everyone has, I think one of the things that we've seen, especially with smaller businesses, it's tough for an owner to get rid of an employee to the point where they don't, because they're just afraid to. And that's never a good situation to be in when someone's not really doing what they're supposed to be doing, but you're afraid, right? You're afraid that this person, which is really interesting and weird to me, because if it's gotten that bad, why would you want this person in your space if you really don't like them? Let's just get rid of them, It's just not that simple though, is it? But it doesn't mean that it's impossible. So when you're dealing with, how do I get rid of a person without having to being concerned about getting sued? What are some things that people should do on that?
Well, that's a really good question. And I find that
Thank you. I have it written down right here. So it's like,
I find that a lot in my practice. As an employment lawyer for businesses, I want our clients to call us when they have these types of issues. I really need to fire Sally. She's been here 2 years. She's just awful, but I just can't get myself to do it. I don't want them to call us as an employment lawyer the first time that they've fired Sally and now they have a lawsuit from Sally because Sally says they did something wrong. The interesting thing about employment law for businesses is we actually can help our clients do things right before they do something like an employment termination that could go south for one reason or another. So what we do is actually review what has gone on in the past and why the practice wants to terminate Sally, for example. And if we get to that point where there's going to be a termination conversation, one of the services we provide is to draft talking points for the business owner, the office manager, whoever's going to have that conversation. And I say, here, this is what you need to say. And then have a conversation with them if they have any questions. And they'll say, well, what if she says this? What do I do? And we kind of talk through it. So I can help role play and put them in a position where they feel better about going forward with that conversation because they have some more information about what to expect, what they can say, what they shouldn't say. And so they're more able to go forward with that.
Can we dig a little deeper on that? Like,
Sure.
What are those talking points and like, what are some things you should say with the things you shouldn't say if you're in that position where you do have to let someone go?
Sure. Well, let's say you're letting somebody go because they haven't been doing their job right. There's some performance issue. Now, I like to say that when you get to a point of telling an employee that their employment is being terminated, the employee should see the handwriting on the wall. The employee should see this coming. However, they can't see it coming if you've not written on the wall. So what that means is to do what we were talking about earlier by having told this employee, here are the expectations. When the employee didn't meet those expectations, somebody has sat with them, gone over, say, here's what's going on. Is there some challenge you're having about meeting these, trying to figure out how to help the employee do their job? And by the time you get to a termination conversation, the person having that conversation should be able to say, as we've discussed, your job requires you to X, Y, Z. We've talked to you about it. We've given you chances. You're still not performing. Unfortunately, we're really disappointed, but a decision's been made to let you go. If you can't say that, if you can't say, as we've discussed, we've talked about this, then you're not ready to let them go because they're going to be surprised. Surprised employees usually sue. They're much more often to sue because they think they're God's gift to the practice. They're doing a wonderful job because nobody told them otherwise. So it must be that you're letting them go because of their age or their race or their national origin or something else, which is what the employment discrimination laws protect. Obviously, you can't let somebody go because they're black, brown, pink, or purple.
Right.
You have to let them go for a business reason, such as they're not doing their job or they're always late or some other thing that's distracting or upsetting to the practice.
Okay, I got a couple questions now because all right, we're in Florida, right?
Okay.
So this is everything I've ever heard. We're in is an at-will state. Is that right?
Yes.
Okay. So I'm thinking like, hey, I can get rid of anybody I want to anytime I want to. I don't have to give you a reason why I want to fire you. Tell me why I am absolutely cuckoo for Cocoa Puffs on that one.
You are cuckoo for Cocoa
Okay,
Puffs.
thank you. So I'm going to be happy about that one because I've had moments like that, but
I can explain.
Okay.
So, yes, most states in the U.S. are what's called at-will states. I'll tell you, Montana is not, and California has some weird things, and a couple of other states do, which we're not going to get into. But
I'm not surprised at California. I'm surprised at Montana, though.
I
That's
was
like,
too, But yeah. Okay, so this is what at-will employment means. At-will employment means that the employment relationship exists at the will of the parties to it, the employee and the employer. So as long as the employer and the employer want it to happen, as long as they will that this relationship continue, then the relationship continues. There's no set time frame on at-will employment. Now, at-will employment can be terminated for a good reason or a bad reason or for no reason at all. It just can't be terminated for an unlawful reason.
Okay.
So a good reason would be those type of things I said earlier. They're not doing their job. They're always late. They're missing deadlines. They're upsetting patients. Something that would be a good reason to let somebody go. A bad reason to let somebody go is probably not what you're thinking. It's the practice owner doesn't like the car they drive, or the baseball team they support, or the basketball team they support.
Yeah.
That's a kind of stupid reason for letting somebody go. However, it's not unlawful for somebody in Boston to fire the Yankees fan. Okay.
I'm glad I don't have any Michigan Wolverines that work for us right now, but I'd still,
So that's a bad reason. No reason at all. You can fire somebody for no reason. You can put employee names in a hat, pick out one and let them go. It's really stupid for a business owner to do that, but it's lawful. What's not lawful is letting somebody go for discrimination because, as I said, their race, national origin, age, they're pregnant, something like that. It's not lawful to let them go because you're retaliating against them. For example, if somebody in the practice called OSHA for a safety violation and you say, okay, they're a blabbermouth, I want to let them go. No, that would be a really bad idea. That's
okay. That makes sense.
So that when you're at will, you can sort of let them go for kind of any reason. And it may be that the practice has a good reason, but the employee can say, you fired me because I called OSHA or because of my race or because I just made a complaint of harassment. And that's really why you're firing me.
Got it. So it doesn't prevent them from coming back and still suing you if they want to.
No.
So it's still a terrible way to get rid of somebody.
So part of what we do in consulting with a client before they let somebody go is go over all the potential things that the employee could raise as a claim and see if there are claims and if there are things we can do about it before letting the employee go.
Okay. Now, are there some things that someone does that are just so egregious that it's like, I don't need to say, as we discussed before, are there like a tier of things that someone does that are just like, I mean, someone's ripping you off or, if are there some certain, I guess, actionable items, which are immediate and you don't need to have that kind of discussion or documentation with the person?
Yes, I am putting a but behind that.
Of course.
If somebody punches out somebody gets violent at work, somebody, runs over a patient in the parking lot, does
bad.
something really violent. You find out that they're stealing petty cash. You find out that they've given patient names and contact information to a competitor. There are certain things that you probably can let somebody, they come to work drunk.
Yeah.
Certain things that you probably could let somebody go right away. But depending on the state, the circumstances, and some other factors, I would actually recommend in some of those circumstances that you suspend the person pending an investigation to make sure you have the facts right about what happened, so that you can collect things. You can call your friendly employment lawyer. You can talk to the person you just suspended, make sure you get their side of the story, and then you let them go once you make sure all your ducks are in a row.
Okay, that makes sense. So there are some things, but you still you want to be careful before you pull the trigger on something like that. I would figure, if someone's violent, it's probably, a way to do that. But you have poor performers in the business. What is some of the ways that we can do to get rid of these people? I hate to say it that way, because you always try to get people to correct themselves, but at some point in time, you have to confront, okay, this person just can't do this job. How many times do you have to, is there a rule? Okay, I got to give them at least 3 chances, or I have to give them at least 2 chances, or I have to, are there some best practices when it comes to that? And then I guess, how often should you be meeting with an employee to go over their performance? Are there some standards there? That's a lot of questions right there.
That's a number of questions.
Yes.
So let me try to unpack them. And if I forget any of them, you can ask me again. So when it comes to employee performance, and I'm only saying this next thing because I know you can edit this, but you're frozen. So are we connected?
Yeah, we're connected. Don't worry. Sometimes it does freeze while we're recording, but it'll be okay.
So when you're dealing with employee performance issues, I think of them as 2 different categories. One of them has to do with how the employee is doing his or her job. And that is something that perhaps the employee needs to learn. Perhaps there's more training. Perhaps there are certain skills associated with that job where the employee may have the general idea how to do it, but there may be, for example, a dental hygienist who has good hygiene skills, but her communication skills with patients aren't that great. And perhaps there's some training that could be done to help with those skills. But then there's another area of things, such as people who are always late, or people who don't turn in reports on time, where I look at those more as discipline than training. So you're going to approach those different areas in a different way. Now, to answer your question about how many chances do you give somebody, I say it's as many as you can stand until the person's going to make the termination decision, is just kind of fed up. Probably at least 1 or 2, but it depends on the situation. Is this something the person can fix, or is it not? Sometimes when it comes to a performance, how they're doing their job, perhaps the practice made a mistake when they were hiring and they didn't ask enough questions and they didn't dig into the person's background. Let's say they were hiring a bookkeeper who really didn't have the bookkeeping skills that they were looking for, or somebody to be an insurance biller who claimed they dealt with this before and they really never did. And so they're completely overwhelmed with all those insurance codes. Is this something you want to train, or was this what's called a mishire and they never should have been hired in the first place? So if it's a situation where you can't train, you don't think the person's going to get it, or you don't want to invest in training, perhaps you want to let them go sooner than someone else who seems to be a good culture fit, seems to get the practice, seems to want to service this kind of patient and just needs a little bit more training. You may give that person more chances to improve and see if they're moving along in that direction. Somebody who's late all the time and just can't get themselves there, that may be a kind of 3 strikes you're out situation. Because that person either should get themselves there on time, or, they really can't work there.
Gotcha. So there would be a difference in the type of, I don't want to call it misbehavior, but whatever it would be. Some of these things could be more disciplinary. Some of these things could be more of just the training and the person's ability. And you may need to separate those two. Is there anything about like initially when someone comes on that they have that you say, okay, you have a probationary period here. We're going to see how you're going to do. Cause I'm sure you've heard the term, like, we're going to hire fast, we're going to fire fast. And you probably can't stand that when you hear that, but is that something that is okay to do? I mean, as long as the person understands, as we've discussed, we have a probationary period. I mean, are those things even, what's your opinion on those?
Businesses shouldn't use probationary periods.
Okay.
I'll tell you
That's
why.
good.
Because when someone's employed at will, you can fire them at any time for any reason.
Yeah.
You don't need to designate the first 3 months as something special to show us how good you are. What happens if they've sort of been on their best behavior for 3 months and then in the 4th month after they're off probation, they're absolutely awful? Why can't you fire them in the 4th month? So it's perfectly okay after 3 months to give the person a performance review, to go over how things are going and give them a sense on whether it's working or not. But you don't have to call the initial period probationary. Another reason not to do that is that, let's say somebody sues and they say, well, I passed my probationary period, so I must have been doing my job just fine. Otherwise, they would have fired me during probation. Now, if this goes to a court, the judge is probably going to think that, okay, they passed probation. So once they get on the other side of probation, that must mean something. If the practice put in a probationary period and they got over that successfully, now what? Now what's their status? If they were at will before during probation and could be fired for any reason, now what's their status on the other side of a successful probation? Where judges have looked in order to determine what that status is actually to the union context. Because I'm sure most of your practices are not unionized and do not have union employees, I would guess. However, in the union context, union employees are hired for a probationary period, usually 90 days or 3 months, during which they're like at will, and you can fire them for any reason. After the 90 days, they can only be fired for just cause. They're no longer at will. And what's just cause? It's actually whatever the arbitrator says it is. Because terminations in the union context can go through a grievance process and before an arbitrator to decide if the person should have been terminated. And the arbitrator can say, well, you didn't have just cause, and now you have to take the person back. And you don't want that in a private business setting. So you don't want to destroy people's at-will status by having a probationary period. So you don't need a probation. I'm hesitating because another reason why people say they have a probation is because they don't want to start benefits for 90 days.
Yeah.
Which is, okay, fine. So start benefits after 90 days. Why do you have to
you don't need to call it a probationary period at that point.
Exactly. So, yeah, those are my thoughts on probation.
Okay. Performance reviews. Like, how often should those be done?
There's 2 different things with performance reviews. One, I think a global performance review should be done annually, but the employee should know everything in it already, because managers really should be telling employees how they're doing on a regular basis. I know it's not as easy in a practice setting as, some other businesses. Managers have check-ins with their employees every week, every other week, talk about how they're doing, what they're working on. Also, if let's say an employee is supposed to put together a particular report for the practice owner, and the report is either late, insufficient, doesn't have the information he or she needed, then the practice owner should sit down with that employee right then and say, hey, this is what I needed. I didn't get it. I really need you to go back and fill in these gaps. So that performance management is an ongoing thing. Throughout the year, it goes over, on a regular basis. So the annual performance review is something to kind of go over the whole year, see how the employee's doing, and maybe set some goals for the new year? Does the employee want some training on something? Do they maybe want to move up in the organization or perhaps move over in the organization? Does somebody who's been working in the front want to see what it might be to work in the back, of a practice, and really get some communication about the person's future with the organization? So in terms of having more formal performance reviews, some businesses do it, every 6 months, not just annually. It's really what works for the business and who's going to be doing it. Because if a practice owner has 10 to 15 employees and the practice owner is going to be doing it, that's a lot of his or her time.
Yeah. And that's going to go into my next question too, which is the documentation of that, because that's where it's like sometimes, and I've had this too, where I'll have a conversation with someone and then, I'll just forget to document what I said. Like, how do you, like, do you just have like a template keep a folder on in your file? Like what's the best way to document these reviews, or when you have a conversation with someone? I'm assuming all those things are going to be required. If it got to the point where there was a lawsuit against someone, that you had this documentation, date, time, all that. I mean, is that what's required, do you think? And what are some best practices on that?
Those are very good questions. There's two types of documentation. One is internal documentation that's going to go into the employee's personnel file that the employee is not necessarily going to see. And the other is documentation that goes to the employee. So when there's a conversation, the easiest thing to do is hopefully the practice has practice email and can send the employee an email. As we discussed yesterday, I've been looking at, your callbacks or whatever it is, and you just haven't been spending enough time. Doesn't look like you're making enough calls. And, I really need you to focus on this in the coming week. Let me know if you have any questions. So
boom. So you got documentation right there.
So you have documentation, and it's a simple email, and you're summarizing what you just told them. And it goes to the employee. You can also say, please respond to this employee to let me know you got it. Respond to this email, let me know you got it, and let me know if you have any questions. So that's what.
That's excellent.
The other, the internal is a memo. It can be an email somebody sends to themselves if they prefer, or just something they type up quickly about what happened in that conversation. Because there may be things that occurred that you want to document, but you don't want to put in the email to the employee. For example, I spoke with the hygienist who, when she doesn't have patients, is supposed to be doing recalls, and I found her reading a novel more than once. So I talked to her about it, and she got really defensive, and she got angry at me. You want to document that in your internal, but you don't want to necessarily say that in the email
to
the employee.
Yeah, that makes sense. All right, I'm going to ask you I want to say it's the worst story that you've had, but give me a scary story of some of the things that we talked about with an owner that didn't do these, and what was the outcome of that? Do you have one off the top?
Let me see.
Obviously no names are going to be mentioned, but yeah.
One of them was an African-American employee who wasn't doing her job. I'm not particularly picking on someone of a particular race. It just happened to be the situation here.
I understand.
She had complained that she felt she was being treated improperly because of her race. And happened to be a practice, didn't do anything about it, didn't look into it, and fired her because she wasn't doing her job without specifically having met with her about what it was she wasn't doing right. So there were a couple of things that the practice had done wrong. They got sued because she made all these allegations that I made a complaint. You didn't deal with it. You never told me I wasn't doing my job right. Must have been because of my race that you let me go, because I had just made a complaint because of my race. So there were all these loose ends that the business hadn't dealt with before they decided to let her go. And what had happened is she had, on her last day, come in late and said something nasty to the receptionist when she arrived. The practice manager was standing there and he said, "Okay, enough, you're fired." He didn't even talk to the business owner, knew that she was sort of on the chopping block, didn't consult with anyone. So that's a situation of a manager acting kind of out of the scope of his employment. He shouldn't have done that. He should have consulted. She shouldn't have walked in and said something nasty to the receptionist either. But
for sure,
one of these series of improper and unfortunate events that wound up the practice getting sued.
And then what are some of the financial penalties that you've seen? Like, I mean, how much are we talking about here? Because I think it's one thing, you know, when you say I'm going to get sued, people all of a sudden just go, oh my gosh, I'm going to go bankrupt. But, you know, a lot of lawsuits settle for $5,000, $10,000, $25,000. You know, when it comes to this area, like what, I'm sure it's varying degrees of, you know, in case specific, but I mean, can you give me any stats of like, you know, what some of these penalties could be?
Well, they don't settle for 5 or 10,000 anymore. Inflation.
Okay, yeah, the good old days, right? They're gone.
So very often the resolution is a function of the employee's salary. What do they make a year, and how long have they been there? But the types of things that employees could claim, one is actual lost wages. So if they're let go and they didn't get a job for a while, then how much in actual lost wages do they have? If the job that they got pays them less than they had before, then there's the difference of the compensation going forward for some amount of time. They can also claim emotional distress damages. Oh my goodness, I was so hurt by being let go.
Yes.
Excuse me. Now, there's two types of emotional distress. If there was actually some type of harassment or improper activity at work, and sometimes there is, we have to acknowledge it unfortunately does happen, and that person really was somehow emotionally harmed, we would expect them to have gone to a doctor or a therapist or have some kind of counseling or something to address that emotional state that they're trying to get compensated for. There's also what we lawyers call garden variety emotional distress, which is the kind of distress everybody has when you get fired. You know,
yeah, I'm sure
it's not a great situation and everybody's upset by that. And garden variety emotional distress has some emotional value. It has some monetary value, but not nearly as much as if there really was some wrongdoing to the person. Or if the person, for example, was like forced to work in the basement that was dank and cold and had rats. There are those claims. Then in an employment case, the employee that prevails gets their attorney's fees paid for by the employer. So that's something that could be a chunk of change.
Yes.
If something really bad happened at work and they prove it, this usually happens in sort of a sexual harassment context or some other type of bad harassment context, then the employee can get what are called punitive damages. Punitive is a word that means punishment. So punitive damages are damages intended to punish the employer for letting something happen. How much those punitive damages are usually some multiple of the other damages. So it really varies. When things settle, I would say that most cases that maybe something happened, maybe it didn't, it doesn't look quite right, it's going to cost a lot to litigate, they probably settle somewhere between 30 and 70,000. So that's kind of a range that business owners look at. Plus my fees. So
yeah, exactly.
Yeah.
So is there a type of, I mean, does the professional liability insurance, that would just be if there was something with them medically. Is there a type of insurance that you have that you can get that would cover or help at least offset some of those costs?
There's something called employment practices liability insurance, EPLI. Okay. Now, I and the other attorneys that work with me at Greenwald Doherty have mixed feelings about how this insurance actually helps or doesn't help. The reason is that very often the insurance company has a panel of lawyers that get assigned these cases. Those lawyers make money by volume, so they're not very responsive very often, and they're trying to handle a lot of cases, and they're also trying to string them out, because the longer they string out a case, the more money they get on it.
Right.
I actually have a client right now that has a matter being handled by their EPLI policy, and the insurance counsel is just not responsive. In my mind, this has been going on for months and months and months. They've been discussing potential settlements. It should have settled months ago, and it's driving everybody a little crazy. So in some cases, it can be helpful. Not all insurance panel counsel is awful. Some of them are reputable employment firms. But that insurance can be something that can help.
Is there an amount that you would recommend, depending upon the size of the practice, that some, like a rule of thumb that someone should get?
It should cover $1 million each claim. They really should be hefty policies. Employment claims usually when it's a single person, a small business, they're usually not in that realm unless something really bad happened. But I have seen, especially for some of my dentists and other medical practice clients, that an insurance broker will tack on an EPLI policy, but it only covers $50,000. That's not.
Yeah, that's not enough.
Almost not worth having. Even $100,000 if it's going to litigation to go through either an agency or a court. It really has to be much more than that to give the coverage that the practice needs.
Okay. I got to check with Diane on that one. I don't know if we have that or not. So, anyway, wow, this was great. I got a lot of questions answered on this. So I really want to thank you for being on here. So, people definitely need to connect with, if they need to connect with you, what's the best way for them to do that?
The best way is probably by email. So my law firm is Greenwald Doherty. My email is my initials DL at Greenwald, GREENWALD DL at GreenwaldLLP.com. Our law firm is located in New York. I'm in Kentucky, actually. And
yes. What part? What part of Kentucky you live in?
South Central, pretty close to the Tennessee border.
Okay.
Yeah.
I may want to talk to you about some other things besides the land there, but we can do that off screen. But great, and you can work with anybody in all 50 states.
Pretty much, it really depends on the situation. The attorneys in my firm are admitted to practice in multiple states. For example, I'm admitted in Kentucky, New York, and New Jersey, and most of my colleagues have 3 or 4 states also. So we cover a lot of ground, mostly on the Eastern Seaboard, but then also we've got Texas and California and some other places as well. And the best thing for somebody to do is reach out if they have a question, and we'll let you know if we can handle it. And if not, we have a network of employment lawyer colleagues in a lot of other states. We can very often find someone else who can help.
Excellent. Don't Don't use Google for things
No.
like this. Make sure you go to an attorney and make sure you have the proper procedures set up so that you protect your business, you protect yourself, you protect, the things that you've built up. And I can't thank you enough for being on. So thank you so much, Devora. And we'll see all you guys on the next podcast.
Oh, you're very welcome. My pleasure. Thanks for having me.